Welcome to Jimenez Floyd Family Law Firm. Today we're going to discuss with you some child custody stuff. Specifically, we're going to talk about conservatorships and stuff like that. Here to do so, we have myself. I'm Josh Floyd. I'm board certified family law attorney. And we have,
Christina Jimenez.
who's also board certified, although she doesn't want to say. And so specifically, we're going to dive into kind of the difference in, joint managing and sole managing conservators and what that means to the ordinary person.
And so just for, I guess, context, as we're going through and explaining this stuff, we have been advised to try to simplify it and make it simple so that you guys, just a common layperson that just happens upon our website, that you guys can potentially understand it, right? And so just know that once you get into the actual legal process, these words are going to change and the way things will be explained to you are going to change. But we want to make sure that you guys have the ability to understand this and that you find some sort of value in what we're sharing with you guys today. So anytime you have a custody dispute and you go to court and you're requesting orders from the judge is going to either appoint you both as joint managing conservators, or will sometimes appoint a parent as sole managing conservator and then the other parent as possessory conservator. And so joint managing conservators, Floyd, how would you explain that?
So the way I always explain it is with conservatorship, we're talking about your parental rights and duties, right? So just the rights that you have as a parent. The right to make educational decisions, medical decisions, military decisions, just the normal day-to-day decisions, right? But our great legislatures have sat down and listed them all out. And I think, I don't know, it's 23, 24 of them. I haven't added them up, but there's a bunch of them. And so I always explain like it's broken into two different sections, right? Your first section being your right to receive information about the child, and the second section being the right to make decisions concerning the child. And so when we're talking about a joint managing conservatorship, both parents have the exact same rights and duties in both sections, except for generally speaking, one parent will have what we call the exclusive right to designate the primary residence of the child. Some people call that the primary parent or the parent that has custody, right? Those common terms are used. But basically, that's where the child lives or the parent that the child lives with. So, joint managing, everybody has all of the rights except for one parent the child lives with.
And so the other thing is in the context of a joint managing conservatorship, the main one is where does the child live, right? The exclusive right to designate the residence. But a lot of parents also want to focus on what we call med, head, and dead. Okay. And so the first is invasive medical decisions. And so the second is psychological and psychiatric decisions. And then the first or the last rather is educational decisions. And so, in the context of a joint managing conservatorship, the court can grant one parent exclusive rights. The court can do independent after conference, or the court can do, independent. The court can also do exclusive after conference, right? And so, you have to be sure that you sit down and you visit with your attorney about why these rights are important to you. And if you feel like it's important that you should have the exclusive right to make these decisions, make sure that you're providing context to that attorney and you are giving really good reasons for having those exclusive rights, right? In my, opinion, and in most cases that I see, courts are typically inclined to do the independent after conference, right? And so explain what independent after conference means.
So it means that you have the ability to make the decision. Each parent can make the decision. It doesn't require an agreement, but after conference requires that you confer with the other parent before making that decision. So, for example, with psychological, right? If I want to enroll the child in counseling, I would have to call the mother of the children and say, hey, I think that we need to put this child in counseling. This is what I think, blah, blah, blah. And whether she says yes or no really doesn't matter, right? I still have the independent right to do so, but the court's requiring me to confer with the other parent first before making that decision.
And so, a lot of times we get these fact patterns or these cases where the parents just cannot communicate. Like they cannot agree on the time of day. And when that happens, that's really when we see this need to do the exclusive rights, right? Or to request the exclusive rights. Because if, let's say, you both have independent after conference, and mom wants to put the kiddo in therapy and dad does not want to put the kiddo in therapy, then inevitably what you see is dad's like, okay, I'm not taking the kiddo to therapy during my periods of possession, or I'm pulling him from therapy, or I'm not going to give the child their ADHD medication, or I know that you were going to take them to get their tonsils taken out, but I'm calling the doctor and I'm going to tell him that he can't do it. And so then you get all of this back and forth as it pertains to the kiddos. And that's typically when a judge is going to say, okay, now y'all's inability to get along is interfering with the best interest of this child. So now only one parent gets to make the decision, right? And it can be all of the decisions. It can be some of the decisions. You can still be joint managing conservatorship or have joint managing conservatorship and have all exclusive rights go to one parent. I guess most exclusive rights go to one parent. But typically the independent after conference is what I prefer, because I think most of the time the parents are going to do what's in the child's best interest. I'd say 95% of our cases.
Yeah, I mean, you do have those cases where they're just so adverse that whatever one person says, the other person is against it, no matter how they really feel about it, just to be against it, right?
Right.
And there's one judge that does after meaningful consultation and actually defines what meaningful consultation is, right? And so there's all kinds of variations on the way judges structure this to try to make sure that you guys are co-parenting and doing what's best for the children. But yeah, it can be nuts.
So I would say, independent, exclusive after conference, whatever it is always in your best interest if you're making these major decisions to confer with the other parent, right? Because judges will look at that in the context of a modification to see, okay, did mom just take this kiddo? Mom had independent right to make this decision, and she just took the kiddo to go and get the child's tonsils taken out and didn't confer with dad. That typically could and probably would result in you losing that independent right, and now the exclusive right's going to dad because you're not sharing information. So best practices, always share information like that.
Overshare, I agree.
Yep. So joint managing is typically what you're going to see in, I don't know, probably 90% of our cases, right? And so Texas Family Code has stated that it is in the best interest of the children, or presumed to be in the best interest of the children, that a parent be appointed as a joint managing conservator. And in order to rebut that presumption, you have to show reasons why that parent shouldn't be a joint managing conservator. And so what are some of the ways that we do that?
So the big ones, right? Family violence, drug use, criminal histories, child abuse, child neglect, things like that. But then also you just co-parenting, like you're talking about, right? Inability to co-parent. If you can't co-parent for the best interest of your children, then the judge is going to name somebody a sole managing conservator, and give all those exclusive rights or whatever they need to do. So I think those are the big ones.
And so when a parent is appointed as a sole managing conservator, essentially all of the decision-making powers, so invasive medical, psychological, psychiatric, allowing them to enlist in the armed forces, to manage their earnings, etc. Is the enlistment in armed forces still by agreement in the sole? Or is it all exclusive?
No, it's all exclusive.
Okay. And so all of those rights go only to the sole managing conservator. Now, here's the important thing, and this is something that I've had some sole managing conservators get upset about, and that is the fact that they have to continue to share information with the possessory conservator, the one who doesn't have any decision-making powers. And so it's important for you to understand that in either context, that other parent is still entitled to information about their children, either from you and or from third parties. Those are not going to change, right? And so anything else on the soul managing?
No, I don't think so.
Okay, so when we're looking at rebutting the joint managing conservatorship, if you feel like your case would require it, make sure that you're talking to your attorneys about, okay, here's the family violence, the drug use, the criminal history, the lack of cooperation, the lack of being present, etc. And then maybe they could get you over to a sole managing conservatorship. Otherwise, be prepared to have a joint managing conservatorship in place, and then talk to your attorney about whether we need to make it exclusive, independent, conference, etc. Thank you for watching.